Today, I want to talk about dispute resolution, which might lead to litigation. And I want to point out three things that are relevant in every situation where a dispute arises and every situation where you are in litigation. The first of those 3 points relates to the question of cost. It costs a lot, and the costs are often in what economists call a J-curve. So the letter J involves a bottom area, and then it rises, and then it becomes perpendicular. That describes the costs in litigation too. When you are actually in the final hearing, which might be months away, years away, the costs are perpendicular. Every day you're spending thousands of dollars on barristers, solicitors, yourself out of work, witnesses, etc. So the J-curve must be kept in mind, and the fact that it gets perpendicular. The second thing to have in mind is the role that is played by formal documents. And the most important document I'll get to in the third and final point. But on this second point about the formal documents, things like the statement of claim and the defence and lots of interlocutory proceedings, which are tactical little battles that occur before a final hearing, they can be very expensive. Those formal documents can involve days, weeks of drafting. And it's often an investment that gets very little return, for the reason that the formal documents are often only considered properly at the hearing, whereas everybody tends to be quite immersed in trying to understand the evidence and determine whether they should settle or not. And so the evidence is what should receive the focus, which leads to the third point. If you want to resolve a dispute early, if you want to resolve litigation early, focus on the evidence. If you are a plaintiff, the person wanting to make a claim, write a letter. Get your lawyer to help you with it. The lawyer usually should write the letter. The demand letter that you write has 3 sections. The first section is facts, lots of them. The second section is the law. It need only often be a few paragraphs. You're just citing statutes, or you're citing court case decisions or certain principles of law. The third section of the demand letter is the demands that you make, what you want the other side to do, whether it's stop doing something, paying money, talk to you, make an apology, whatever. Okay, so that's what you do when you are wishing to make a claim and write your demand letter. So what do you do when you receive such a letter if you're defending? Well, your job is to pick holes in those 3 areas. And usually the focus point is in the first area. Focus on the facts. Focus on the evidence. Which leads to the conclusion that the avoidance of litigation is really about good record keeping, understanding your business, understanding the business of others, and marshalling evidence to defend yourself for when you need. And spend your money on evidence assessment, evidence analysis, evidence record keeping. Try to keep out of court.